Hello, I'm Ariella Wagner, and today we have another fabulous seminar conducted by Alex Barthet from the Barthet Law Firm. And today's topic is I'm owed a few $1,000s. Is it worth hiring a lawyer? As a small introduction to myself, I am the founder of SunRay Construction Solutions, a national preliminary notice service. We help subcontractors and suppliers secure their lien and bond claim rights. And without further ado, I will have Alex introduce himself.
Thanks, Ariella. My name is Alex Barthet. I'm a board-certified construction lawyer in Florida. And today we're going to talk about how you can go about securing your rights to be paid and to collect that money, especially if you're only owed a few $1,000s. So let's go through the specific agenda that we're going to go over today. So number one, we're going to talk about the steps to try on your own before hiring a lawyer. Then I'll explain what a lawyer can do that you can't. Then we'll talk about how you can recover your legal fees, which is a very important topic, right? If you're going to have to hire a lawyer and you have to spend money, how do you recover those legal fees? We'll talk about how to file a claim in small claims court yourself if you decide to do it. And then we'll answer any questions that you have throughout the seminar. And with respect to those questions, you can go ahead and use the GoToWebinar chat box. Make sure not to include any names of people or companies in your questions. And with that, let's get started. So what steps can you use on your own before you have to hire a lawyer? So the number one thing I would recommend that you do is start early. And early means having a written agreement that is fair, that addresses payment, and specifically addresses non-payment. What happens if you are not paid on a project? What are your rights? So we see as construction lawyers lots of contracts on a daily basis. And I would tell you that many people incorrectly believe that if they are not getting paid, it doesn't matter what their contract says, they have the right to stop working or stop delivering material. And that's not always the case. There are some contracts that actually require that you continue to work, provide labor and or materials to a project, even if you are not being paid. And your remedy is not to stop work, but it's to follow the dispute resolution process that's set forth in the contract, which may mean that you have to go to arbitration or mediation, or you have to litigate in a court of law. But under no circumstances can you stop working. As you can imagine, that's a very difficult position to be in. And you'd like to know that in advance before you sign that contract. So number one, make sure that you read the contract that you're about to sign, that you understand all of its provisions, that you don't do what some folks do, which is look at the price, the schedule, skip to the scope of work, and then ignore the boilerplate language that may be in that contract that may have a lot of bad things for you. The other thing to consider is maybe having your own terms and conditions or contract that you give to people, and that would be your contract, and that can be written by a lawyer and prepared in a way to protect you over protecting the other side if they give you their contract. What else can you do? You can timely send a notice to owner, even if you don't need to under the lien law. Folks that get a notice to owner will take you more seriously. So even if, for example, you're in direct privity with the owner, you have a direct contract with the owner, you don't need to send a notice to owner. It's recommended that you do. They'll get this document and they'll understand that you're serious about getting paid. The other thing you can do is make sure that you notice every job that you work on. because if you're a supplier to a subcontractor, as an example, once that notice goes out, the owner now will be making sure to get a release from you before they pay the contractor. So it acts as a bit of a check and balance on the payment process to make sure that you get paid. As well, to the extent you need to send it, it ensures that you have lien rights secured. So our advice to our clients is notice every job over a certain threshold that you determine in your office is appropriate. Maybe it's $250, maybe it's $1,000, maybe it's $2,500. But whatever that threshold is, you just have a process in your office that no matter what, you're going to notice all of those jobs. That's a great way to increase the likelihood of getting paid. Next, people don't like to do this, but you need to be able to cut off further credit on this job and other jobs to the extent you're contractually allowed to do that. It's one thing to get burned for $5,000, but you'll feel even worse if you continue to extend credit and then now you're getting burned for $15,000. So when you've made a decision, you are no longer willing to risk a greater loss, and you don't have a good feeling about collectability, you need to cut off that customer. Next, you need to timely record your lien or send your bond claim, which is called a notice of non-payment. Again, this needs to be done no later than 90 days from your last work on the job. You need to make sure that you do this because this is the second step in the lien and bond claim process. So step one is the notice to owner within 45 days of your first work, no later than 45 days from your first work. And the second step is to timely record your lien or send your notice of non-payment no later than 90 days from your last work. It's critical because this is the step that will set you apart from others that haven't followed the lien law, and you now automatically rise to the top of the people that are going to get paid when payment is due. Let me tell you a story. Several years ago, we represented an owner on a hotel condo project that went bad. And there was about 30 lienors that were owed money on this job. And only those that timely served their notice to owner and recorded a lien got paid. So everyone else didn't have lien rights against the owner. They needed to pursue the contractor who went out of business. So those folks that didn't have a lien, they didn't get paid at all. Not a little bit. They didn't get paid at all. Those that had a lien, they did get paid, and they got paid almost all of their money. And that, by the way, that was only about half of the people that performed work on the project. So it's absolutely critical that you timely record your lien or send a bond claim. Finally, call, email, and visit the debtor often. You need to be the squeaky wheel that is going to harass the person that owes you money so that they don't forget about you, and so that when money comes in, they pay you so that you leave them alone. Some of our most successful clients that still send us work on files to collect for them, but they actively work through their credit department to collect the debt. So by the time it comes to us, they've tried absolutely everything. They've gone to the customer's office, they send emails, they make phone calls, and it's only as a last resort that it comes to us. That is the best process that you can employ. So what will a lawyer do for you that you can't? So number one is give you advice on the merits of your case and the likelihood of success. Understand that a competent construction lawyer deals with these types of cases on a regular basis. So they can look at your case, look at the situation, and say, yes, you have a high likelihood of success, or no, this rule or exception to the lien law applies, and as a result, your case isn't very good. So you should consider walking away or settling the case or taking the offer that may be on the table that may be less than you want. So you'll get some ideally candid advice from a competent construction lawyer. Next is they will send a demand letter, a letter demanding payment on the lawyer's letterhead. This is typically the first step that most lawyers will employ, and what it does is it conveys a strong message to the other side that as a result of this outstanding debt, that you've now hired a lawyer, and that if they don't resolve the problem, that a lawsuit may happen. So now they know that you're serious because you've retained the services of a lawyer. And then the next step is a lawsuit, something filed in court, or if your contract requires arbitration, instituting an arbitration. Individuals can represent themselves in court. So irrespective of the amount of the debt, an individual can either prosecute their own case of their own money, or as a defendant. So maybe you have someone that signed a personal guarantee and they owe $50,000. As an individual, they can defend themselves. However, businesses must be represented by a lawyer for cases outside of small claims court. We'll talk about those in a minute, which means any case greater than $5,000. So if you're owed $14,000 and you want to pursue that full amount, you can't do it yourself. And the converse is also true. If you sue a business, an entity that owes you money, and let's say they owe you, $22,000 or $122,000, they'll have to get a lawyer to defend them. They cannot defend themselves. So how do you recover your legal fees in the state of Florida? There's really only two ways. One is a statute, a law on the books that says that the prevailing party is entitled to recover his or her legal fees. In Florida, there are two statutes that govern this issue. Chapter 713, which is the lien statute, and Chapter 627, which is the insurance bond statute, which says that if you sue an owner on a lien and you win, or you sue a surety on a bond and you win, then they are obligated to reimburse you your reasonable legal fees. So you don't need a written agreement in either of those situations, and you can still potentially recover your legal fees. The other way to do it is you need to have a written contract that says that the prevailing party is entitled to recover his or her legal fees. So if you and I sign a contract, well, let's start even simpler. Let's say you and I have a handshake agreement. If I have to sue you because you owe me money, I'm not going to recover my legal fees for this oral agreement, because there's nothing that says that the prevailing party gets their legal fees. Maybe we have a written agreement. Maybe it's a signed purchase order. Maybe it's an invoice with terms and conditions. But if one of the terms and conditions is not that the prevailing party gets their legal fees, then the prevailing party won't recover their legal fees. So you need to have a specific provision in your contract that says that the prevailing party in any dispute is going to recover their legal fees in order to be able to recover your legal fees. But understand that almost every case that we have settles. And what I would suggest to you, and I suggest to most clients that call, is that you change your perspective on the manner in which you think about this. When clients come to us and they're owed $200,000, $500,000, $100,000, usually the offer on the table is zero. The other side is not willing or has not offered to pay anything. So what I tell clients or prospective clients is, it's unfortunate that you're in this situation, but don't think about the legal fees that you're spending as dollars that you absolutely need to collect. Think about it as, this is the cost of getting as much as I can, and what is the least amount of legal fee that I need to spend in order to recover the most amount possible. So for example, let's say you're owed $100,000. Maybe as you sit here today, you're not going to get anything because the other side isn't paying. But maybe you only need to spend $5,000 in legal fees, and the other side is willing to pay you $85,000, either because you forced them into a settlement or for some other reason. It'd be nice to get all your money and interest and legal fees, but many times that's not always doable. And it's better to move on from litigation than it is to fight over absolutely every last nickel. Now, don't get me wrong. We have many clients with cases where we recover everything: interest, legal fees, costs, and the principal balance. But if you go in with that mindset that you're only going to resolve the case if you get everything, you'll find that you may be chasing every last dollar and spending more in the process. So if you decide that you're going to take a case yourself to small claims court, what is the process and how do you go about doing it? So first, you need to understand that if you're going to hire a lawyer, you're going to have to likely spend some money. So how much money is it worth? How much do you need to be owed to make it worth hiring a lawyer? And that really depends on your business. So we have some clients that take their own cases to small claims court, and they send us cases that are bigger than that. And again, I told you that's $5,000. We have other clients who don't want to be hassled, and they send us everything. So they'll send us the big cases and the small cases. And we have other clients that say, you know what, if I'm only owed a few $1,000s, I'm just going to write it off and move on because I don't want to be distracted in my life and my business for this. So it's a very personal decision that you have to make on how much you're willing to spend. But we'll run through some basic costs so you understand kind of what's the minimum that you're going to spend if you have to hire a lawyer. So let's talk about the small claims case so you understand what it is that you can do yourself. And we often recommend to clients and prospective clients that are owed a few $1,000s, why don't you do it yourself? It's not hard. And we have clients that have done it once or twice, and now they make a habit out of just handling all those cases. So a small claims court case has to be less than $5,000, meaning that's the most you can recover. So maybe you're owed $6,200, but you decide to do it yourself. Just know that the court is only going to award you $5,000. So you, in my example, you'd have to chop off $1,200 of your claim and only pursue $5,000. What's the process? First, you file a statement of claim and pay the filing fee, which, depending on the time, because they change the fees, every once in a while, and the county that you're in, you're looking at about $200 or so, $250 to file a small claims case. That's the fee that gets paid to the clerk. The next step is you have to serve the defendant. So either you use the sheriff and pay the sheriff, or you hire a process server to serve the defendant. Usually you're looking at between $50 and $100 to serve the defendant, assuming that they are not avoiding service, meaning hard to find, because if that's the case, you may find that you're going to spend more as the process server is trying to chase down this defendant who does not want to be served. Once you serve the defendant, the court is going to give you what's called a pretrial date. This is the date that you're going to show up to court, not for the trial. That's why it's called a pre-trial. And the court's going to do two things. One, they're going to see if the other side shows up, and if they do, they're going to send you immediately to mediation. That's the process where you and the other side sit down with a neutral third party to try to resolve the case. If you can resolve the case at mediation, which again is going to happen right there, then you will sign a settlement agreement on the spot, which will become an enforceable contract. If not, then after the mediation is over, which will only last about an hour, you'll go back in front of the judge, and the judge will say, okay, how many witnesses are you going to need? Maybe it's one, maybe it's two. And then they will give you a trial date. So now you're going to come back at some point in the future. Usually it's a month to 2 months away. and you'll have your trial. Before that, after the pretrial and after the mediation, you're going to get all of your documents and witnesses in order so that you can actually show up on the date the court gives you to argue your case. So you're going to attend the trial and argue your case, and then the judge will render a verdict, typically on the spot, but sometimes they may take it under advisement and issue an order later. But that's pretty rare. Most of the time they do it right there. And most of those trials will last usually about an hour, maybe 2 hours. Again, for a small claims case, that's normal. Sometimes it's half a day, 3 or 4 hours, but again, most of them happen much more quickly. That's the process that you need to follow. One of the great resources that you need to use is Google. If you Google how to file a small claims case and then you list the county, Dade, Broward, Palm Beach, Osceola, Orange, every clerk is going to have a web page or a PDF on every step of this process, much more detailed than I gave you, and it's going to explain how to file the small claims case yourself. Understand as well that if you go through this process and then you win, you'll get a piece of paper, a judgment that says you won and the other side owes you a certain amount of money. In small claims, maybe it's $2,000, $3,000, $4,000, $5,000. And then it's up to you to collect on that claim, that judgment. So you'll have to garnish bank accounts. You'll have to issue writs of attachment so that you can pick up a car or a van that they may have. You may have to levy on some of their equipment or property, which requires the sheriff to get involved. It's a complicated process, not easy, unfortunately. So don't think that once you get this judgment that now they have to, the other side has to pay you. So keep that in mind. Finally, what are the estimated costs associated with a case that a lawyer may bring for you if you have to sue somebody, so that you can determine, is it worth hiring a lawyer or should I do it myself? To give you some rough numbers, a simple collection case in our office usually costs about $400 to $800 to prepare as far as our professional fees. There'll be another $400 in filing fees and service fees. So, in round numbers, say we're at about $1,000. That's just to start the process. And this is a simple collection case. To the extent it's more complicated, the time it takes to prepare may be more. Once the defendant is served, if they never respond within the time frame, then we get what's called the default. And that default paperwork usually costs several $100s to prepare and file to get a judgment. So in round numbers, you're looking at about $1,500 in the best case scenario to go from someone owing you money to fast forward 60 days later, filing a case, getting it served, getting a default, and now having a judgment against the other side. But as I said, once you have this piece of paper, this judgment, now it's up to you to try to collect on it. So we may have to search for assets and bank accounts. That's usually another $700, $800 for the search. Then once we find something, now we have to execute on it. That may be another $500 to $1,000 to go through that process. Maybe we find a bank account. Maybe there's nothing in it. So now you've spent another $1,500 to garnish a bank account that has nothing in it. Those are kind of the risks and costs associated with pursuing a judgment. But understand as well that sometimes the other side just doesn't give you a default. You have to now fight about it. They hire a lawyer or they defend it themselves, and they say, no, your materials didn't show up on time. The materials were no good. I had to buy replacement materials. Your labor was no good. I had to fix your work. Whatever the process may be, If they defend, it's going to cost more. So even a small case can get very, very expensive. We have a case where we represent an owner who hired a paver company to do work and didn't like the work. The paver company thought he was owed $3,000. The client came to us and said, we want to defend this case because the work was no good. We have to replace it. $25,000 later in legal fees, we still have an open case, and the underlying debt was $3,000. We told the client it's better off if you just pay them and be done, but they chose not to do that. So just be aware that sometimes cases can get out of hand depending on the other lawyer or the other side, but that's where the advice of a lawyer who may help you take the emotion out of it and make a business decision can help you on determining, is the settlement offer that they're making good enough just to move on? Should you pursue the case? Should you do it on your own? Can they help you economically to resolve the case? So with that, if you have any questions, go ahead and submit them in the chat box. Just so you know, we have a few tools that you can use to help you through the lien and bond process. We have an app on the App Store or the Google Play Store to calculate notice to owner and lien deadlines. Just search for The Lien Zone, which is our blog, and you'll find the app. We also have a podcast that comes out every week that's on iTunes, Google Play, Stitcher, or wherever you get your podcasts. And it's usually a 4 to 7 minute episode on some construction contract, lien, bond, or collection issue. So Ariella, are there any questions?
Looks like you did yet another brilliant job and answered everyone's questions. But if anyone does have any questions and they're nervous to ask on this webinar, you can always email us, which will be on the next screen. But we do have our next seminars and webinars on this page. So I'll let Alex continue on with
yeah, we already have our 2019 schedule up on sunraynotice.com/education. So our January 17th webinar is titled "Do This One Thing to Improve Your Collections This Year." We'll talk about ways to improve your credit and collection process in 2019. And then we'll have our first live workshop in Boca Raton, February 12th, where we'll take a deep dive into liens, bonds, contract issues, and collections from 8 to 11. So make sure you join us for those. And again, we have these webinars, free 20-minute webinars every month. And as Ariella said, if you have any questions, feel free to send us an email, give us a call. Otherwise, thanks for joining us. Have a wonderful holiday and New Year. Look forward to seeing you in January.
Happy and healthy New Year to everyone, and have a sunny day.